Hi, estate planning attorney Brian Barboza here, and today I'm going to discuss why you should never put your children on title to your real estate as a means of giving them an inheritance while you're still alive. It's a terrible idea. Before we get started, if you have estate planning questions or you want to talk more about estate planning, please feel free to give me a call or go to my website, barbozalaw.com. I'd be happy to speak with you for free. Just book an appointment directly through my website. Okay, so why you should never, ever put your children on title to your real estate as a way of trying to give them the property when you pass away. Lately, I've had a few people who have come to me, and I've noticed this over the course of years, that sometimes people think it's a good idea to put their children on title to their real estate as a way of giving them the real estate when they pass away. This, again, one more time, it's a terrible idea. So let me explain why that is. First, if you add your child to your real estate as an owner, you've just lost control of your real estate. You now have a new owner on that real estate. That new owner, although you may trust your children endlessly, you never know. There could be a falling out. Maybe they marry somebody that has a different opinion, and then a rift in the family ensues, and that child decides that they want to sell the property or to force a sale of the property. Big problem. They're an owner. They have rights now because they own the property with you. So they could, in theory, force a sale or sell the property. That's a big problem. Number two, your children, maybe they're great with money, but maybe they unfortunately come into some significant debt. Okay, your children end up having debt and they own this property, and now their creditors can get a judgment against them. Their creditors can now put a lien on that property. Those creditors could potentially force a foreclosure of that property, and your child may end up having to file bankruptcy, and the bankruptcy trustee might take that property and sell it and give you your half, and then give the other half to your children's creditors. So again, if you put your child on title to your real estate, now your real estate is subject to your children's creditors and their claims. So maybe the child has great intentions and doesn't plan on selling the property out from under you. However, his creditors don't care about you, and his or her creditors will go ahead and put liens on that property. So there's another reason you do not want to put your children on your real estate. A third reason is if you give your child or put your child on your real estate during your lifetime, you have just given that child a very significant gift during your lifetime, which means that if that gift, the value of that gift is greater than the federal gift tax exemption amount, your child may just have incurred a massive tax liability because you gave him a piece of, or her, a piece of property that exceeded the tax exemption amount. Now, I am not a tax expert. I'm not a CPA, so I cannot give you tax advice. I'm just telling you that there is an issue with putting your child on your real estate because the value of that real estate, it may exceed the gift tax exemption amount, resulting in your child now owing the IRS and I'm in California, so the California State Franchise Tax Board, possibly a lot of money. So again, I'm not a tax professional, but by gifting your child a home during a lifetime, you may have just unfortunately caused your child a massive tax problem. So before you even do that, you would want to talk with a CPA anyways. Okay, so three very good reasons not to put your children on the real estate. Oh, and fourth, if you put them on the real estate and then you want that real estate back, sorry, it's not that easy. You can't just take it back. You put them on as an owner, they now have rights, and they don't have to give it back to you if they don't want to. So there's a fourth reason. So the question then becomes, what do you do? All right, you want to leave your child or give your child your home when you pass away. What you do is you create a trust, and during your lifetime, you create a trust, you put that property into a trust, okay, and then the trust holds that property, and then you make your children a beneficiary of the trust. So when you pass away, that home will then go to your children, and it will avoid what's called probate. It won't have to go through the courts because your trust and the trust document says that your children are to benefit or to receive or inherit your home when you pass away. So that is how you leave your home to your children, is in a trust, and then when you pass away, it goes to your children. Do not add your children to the title of your property while you are still alive, okay? There might be, if you have a very high value estate, there could be reasons to give very small fractional shares to beneficiaries during lifetime, but that's extremely complicated, it's unusual, and you really need to seek an advice of an attorney before you even decide to do anything of that nature. So again, do not put your children on your title of your property. It will be disastrous. Create a trust, put that home into the trust, and then make your children the beneficiary of the trust, okay? That's it. If estate planning is something you are considering or want to talk more about, please feel free to give me a call or go to my website, barbozalaw.com. I'd be happy to speak with you for free about your estate planning needs. And like always, thanks for watching this video. I hope you got something out of it, and have a good rest of your day. All right, thank you. Bye.